Hi, my name is Danyal Ibrahim and I'm an associate at McCabe Curwood Lawyers. Creditors' statutory demands and the intersection with directors' duties. There are good public policy reasons for winding up and deregistering insolvent companies. One of the obvious reasons is to make sure that the wider community isn't entering into transactions with insolvent companies and, more importantly, isn't providing credit to insolvent companies. We don't want too many dormant companies out there, or shelf companies as they are often called, which don't have any prospect of meeting obligations to creditors or paying off their debts. From a creditor's perspective, there is normally a difficult decision to make. That is, whether to spend lots of money on legal proceedings to pursue what could otherwise turn out to be an insolvent company, or simply write off a bad debt. Neither option is a good outcome for the creditor. There is, however, a streamlined process in place that allows creditors to wind up insolvent companies relatively quickly and cheaply. That process involves issuing what's known as a creditor's statutory demand for payment of debt, which will give the debtor 21 days to do one of three things. They are to pay the debt off in full, or reach an agreement to the creditor's satisfaction, or apply to the court to set aside the demand for reasons such as a genuine dispute or an offsetting claim. If the debtor does nothing within the 21 days, a presumption of insolvency arises, which allows the creditor to apply to the court to wind up the company and appoint a liquidator. If the proceedings are not opposed, the entire process could be over in as little as 3 months. For a company that wishes to avoid being wound up and the investigations that will be conducted by a liquidator, receiving a statutory demand is often a strong incentive for the company to pay the amount claimed, or at least enter into negotiations with the creditor. We recently published an article entitled "The Intersection Between Directors' Fiduciary Duties and the Right to Recover Payment," which considers a recent case from the Supreme Court of Queensland. In that case, the director had issued a statutory demand to her own company for a debt said to be owed by the company to the director personally. That case raised some interesting issues because the court had to consider competing interests. On the one hand, the director owes fiduciary duties to the company to which they are appointed and need to act in the best interest of the company. On the other hand, that same director is entitled to be repaid the loan that she had lent to the company and was entitled to take steps to recover that debt, including by issuing a statutory demand. Ultimately, the Supreme Court of Queensland found that the director was not in breach of her fiduciary duties and there was no abuse of process simply because the creditor of the company also happened to be a director. Thank you very much for listening to us. Watch this space for more insolvency news, and please don't hesitate to contact McCabe Curwood Lawyers should you require any advice on this topic.